Hello, everybody. Daniel Gaines here. Back with another brief update. Had an interesting phone call that occurred. I'm not going to play the audio. I do have it. Trust me, I promise. But I'm not going to play it because it's with the appellate court case manager. I could show it. I could play it. Or not show it, but I could play it. However, I'm not going to do that to this person because this person, the appellate case manager, has actually been the most helpful person I've ever dealt with in the state of Washington as far as anybody goes. Absolute pleasure to deal with. Now, it's strictly procedure related issues for the appeal, but it's the appellate court, so that's all it's going to be about. Holy crap! Damn hoodie's got my hair messed up. That in the rain. It's raining outside today. Just got off work. Anyway, during this call, as I told y'all in the last video, opposing counsel, their response brief to my appellate brief was due on the 6th of this month. Here it is. What, the 11th? Yep, the 11th. And still nothing. So I called the case manager to find out steps next, right? She informed me that there's a new due date, and it's May 11th for a response brief. At first, they kind of started to irritate me a little bit. I was like, huh, what? Because I didn't get any notification about a extension being filed or anything else, and I should have been notified. Actually, is what led me to call. Going back real quick, I had an email, and it looked like there was a response. So I called because the response was late, and I was going to see what options were as far as objections or whatever else goes to it being late, and found out that it wasn't a response. It was the deadline had been moved because Stephen Downing called apparently the appellate court case manager, as per procedure, sent the letter to Downing telling him that his brief was past due, telling him if it wasn't filed by this date, he wasn't getting it filed. He needed to either file for an extension or have it filed by this date, or he's SOL. So apparently that prompted Downing to call the case manager this morning, Washington time this morning, and he informed the case manager that he is no longer counsel for the appeal. So he's supposed to be filing a notice of intent to withdraw, and the reason that the 30-day extension was granted is because Juliet has 30 days to inform the appellate court if she's going to file a response brief and file the response brief. So she has 30 days to let them know if she's going to and to do so. And then we go from there. I will be filing the motion requesting accelerated review. I also found out that it will be the actual panel of judges, the appellate court judges, not the commissioners, who will be reviewing this appeal. So it's actually going to be reviewed by the judges, which should end up being a good thing in the end, that it's going to be reviewed by the judges. So, based off my brief, and I'll do a video this week or this weekend, where I'll go over some of the things I bring up in my brief, show some of the evidence, which y'all have already seen, and all that shit. And then if there's a response, I'll obviously put that up here for everybody to see. And then if she does submit a response brief, I have 30 days to do my reply to her response. I'll have that done in literally a day, or filed it the day of or the day after she does that. So it won't take the full 30 days, but I'm going to do the motion for the accelerated review this week to get that filed. That'll be reviewed by the commissioners, but I'm hoping the fact that since it's void orders each and every day that it's delayed, the damages keep going up, and the Constitution and laws keep being violated, I'm hoping that will prompt them to grant the accelerated review, because the evidence is clear on that's exactly what I'm saying is exactly the case. The orders are void, so each and every day that they delay, damages are increased, as well as culpability for the actors in the state who are responsible. Don't smoke, kids. It's bad for you. Kids shouldn't be watching these videos anyway. Y'all know I have a foul mouth. I cuss like a sailor. So, but either way, anybody, don't smoke it. It's stupid. It's bad for you. And I'm an idiot for doing it. I'll be the first to admit I'm an idiot for smoking. Yeah, that's right. I call myself an idiot. And for doing this, I am an idiot. I'm very intelligent in a lot of ways, but in some ways, I'm a dumbass. Anyway, back to the point. See, at least I can be real about myself and who I am. That was a shot at Juliet, for those of you who didn't catch that. But anyway, yeah, interesting development. The timing of it all, to me, is what's suspicious, and why it's as comical as it is. It's funny that he waited until after he reviewed my brief before he said, "Oh, hell no, I'm not dealing with this." So that leads me to wonder, did he bail because Juliet refuses to tell him where she's at, which she's known to do. She's known to bail and not inform her attorneys of where she is. She's known to bail and not keep in communication with her attorneys, to quit contacting them and working with them all together and everything else. That's her MO. It's what she always does, and court records prove this. So I'm wondering if it's that, which is probably what's going to be claimed regardless of anything else. What I'm led to believe it is Downing read my brief. He knows the evidence that's with it because it's with it. He looked it all over, started reviewing things, and realized that in this court he can't rely on wow, why am I blanking on this? He can't rely on communicating with the judge outside of things. There's a term for it. Ex parte communications. Holy shit. Working midnights and then going right into a day job, and then working most afternoons, it catches up to you and causes you to freaking not think at times, or to miss words. Sorry, folks. Bear with me here. He can't engage in ex parte communication with the appellate court. He also can't rely on corruption with the appellate courts. So, based on the fact that in my brief I spell it all out and lay it all out plain as fucking day, as well as I call him out for his fraud upon the court and his conduct, criminal conduct and everything else, and want sanctions, I think he read all that, realized there's nothing he can say or do to get around any of it, realized just how fucked he is because the record and the fact that his client literally has zero evidence to support anything she's ever said, and every bit of the evidence is contradictory to everything she's ever claimed. Even her own documents are contradictory to her claims. I think he finally realized and decided that it's a losing battle at this point, so he needs to just cut tail and run. Downing's always been a fucking coward. He's always had to rely on the courts to cover his ass. He's never been able to fucking hold a candle to me legally. And I'm not an attorney who's been doing it for 40 years. This clown literally went to law school and has 20 years on learning on me, or potential to learn on me. He's been practicing law for 40 fucking years almost. I've only been doing this shit for 18. And this dude can't even come close. Isn't that just sad and pathetic? And doesn't that tell you a lot about the sad state of affairs that the family law courts are in? The fact that a 40-year lawyer doesn't know enough case law to be able to beat somebody who's never even stepped foot in a law library? Yeah, and that's real. I've never stepped foot in a law library. It's not to say I've never done any research into the matter, because that's why they can't hold a candle to me, because I've spent far more time researching than they have. Attorneys talk about how you got to read all this case law and blah 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 going through law school. I promise and guarantee that most attorneys in this country, I've read 5 times as much case law as they have. And whenever I read case law, I don't just read the opinions. I don't just read the quoted text that people cite. If I see a piece of case law that I think might apply, I actually go read the entirety of the case. All of it, all documents available throughout the every step of the process, whether it be appeals, state Supreme Court, federal courts, all the way up to the U.S. Supreme. It don't matter. I read all of it because it's not just a quote from a piece of case law that makes a piece of case law applicable. It's facts of the case. Are there similarities in the nature of the case? That's what makes case law applicable and gives it the better standing in court, not just a single quote. So, always best to actually read the fucking case. Very time consuming. It's a lot. It will overwhelm the fuck out of people. It's difficult to understand if you're not familiar with with legal jargon and all that shit. So it's best to do with a Black's Law Dictionary sitting right next to you, which I've shown several times over. I have one, and usually whenever I'm dealing with courts, I keep it next to me. If I'm doing research, I don't. However, if there's a word I need to, I will go grab it and look it up. As much research and stuff as I've done, most of the words that you see in court documents, I already know what they are and what they mean, so I don't need to look them up, and it's rare anymore that I come across a term I haven't before, that I haven't already looked up a few times, and it doesn't take me more than 2 or 3 times of looking something up, and that's even the rare ones, before I know what they are. I remember things. I'm blessed that way, very thankful, but blessed that way. My recall is excellent. That's what I refer to as being blessed in that way with my memory and recall ability. But yeah, I read entire cases, and that's how I'm able to cite the cases that I am and apply them the way that I do, because I understand the nature of the case that was reviewed or that the ruling was issued based on. I also understand the ramifications of language in law. Like, for example, you see a lot of those First Amendment audit videos on YouTube, Facebook, and all that bullshit, right? And one of the common pieces of case law that you'll hear these people cite in certain videos is Turner v. Driver. I believe it was a 2016 Supreme Court case. The year is the only thing I might be off on, but it was U.S. Supreme Court, and it is Turner v. Driver. And it was about a guy who was arrested for filming the police from a public sidewalk. Police arrested him, charged him, and blah, blah, blah. You go read the case. It's actually fairly interesting. Well, it ended up going all the way to the Supreme Court, where the Supreme Court, in their opinion, whenever they ruled on it, stated that public officials, in the course of their official duty, can be recorded without their knowledge and without their consent from publicly accessible places, only subject to reasonable time, place, and manner restrictions, which are in some circumstances easy to get around, in other circumstances not so much. Public officials and public servants, judges, police officers, court actors, state actors, government actors, military, all those people, they're public servants and public officials. DCYF, child support agencies, all of those people, because their agencies receive taxpayer funding and state and federal dollars, because they receive that funding, they're public officials and or public servants, depending on their job title. Child support, all that's public servants, would be their official categorization. Not public officials, they're just public servants. Judges, they're public officials. But anyway, these people are all public employees. As such, if they're conducting their official business from a place that's publicly accessible, out in public, publicly accessible lobby, a courtroom that's open to the public, any of those places, you do not need their consent. Now, see, the court case was about police, recording police. Nothing else, just police. However, the Supreme Court ruling, they said public servants and public employee and public officials. Public servants, public officials. That's a lot more than just police. That's where words matter in law. So that's why it's important to read entirety of cases, not just a quote or two. There's oftentimes going to be nuances or things like that might make or break your ability to cite a specific case in a specific circumstance. And you don't want to be one of those fools who cite a case who has no fucking clue what they're talking about, to where they just end up getting destroyed in court because, well, they have no fucking clue what they're talking about. It's always best to go in prepared, or to at least go in, if you're not 100% prepared, nerves or whatever else, at least go in knowledgeable and calm. That way you can actually articulate this stuff. I know it sounds kind of ironic coming from me whenever y'all have heard me cuss out judges and everything else. However, I'm always controlled whenever I'm losing control. It's on purpose. It's done to try and elicit a response from them to get them to further deprive me of my rights. See, the thing of it is, a judge will tell you can't cuss in their courtroom. The First Amendment, Supreme Court has ruled, protects profanity. They might not like it, but it's protected free speech. And if you're cussing out a public official in a public forum, that is redressing a grievance. Also First Amendment protected. It's protesting. Supreme Court's ruled on this. Go look up the case law. Y'all can find it. It's very easy to find. Seriously, it is. As such, your free speech rights are not limited or restricted simply because you're in court or simply because a judge doesn't like it. You've heard these judges threaten me over my language multiple times. You've also heard me call them out on it multiple times. Tell me one law or one piece of case law that says my rights are restricted because I'm in court and I'll stop. I don't stop. They don't do shit. I want them to do something, because if they kick it to a criminal court, they're fucked. They're smart enough to know what I'm trying to do, what I want them to do, so they won't do it. That's why they allow me to. But it's always controlled. Do I get pissed off? Yes, I do. When they start violating my rights, I do get pissed off. So it's not like I'm intentionally acting angry. No, I'm pissed off, but it's controlled. I don't lose control. Even when I'm pissed off, I'm still in control. I'm still able to think clearly and rationally. I just no longer owe them any fucking respect or courtesy once they start violating the law and violating my rights. So at that point, it's no longer trying to be civil or courteous. It's fuck them. Because if you look at every court hearing where I've cussed them out or been an asshole, it was after I made an accusation of them violating a right or violating a law, or after they blatantly did. Sometimes I don't know if I necessarily made the claim or called it out, but in the times I didn't, it was blatant, or I had already said something about it and they kept going with it, and that's what caused it. Fuck them. I have the right to be pissed off, to be upset, to be everything else. I have that right. And the Supreme Court has already ruled that that cannot be used against me, because that's how normal fucking people react to violations of their rights. Dumbasses. Not you guys. These, you know I'm talking about, these fucking idiots. Y'all have seen it. Y'all know they're dumbasses. However, thankfully, I think it's about to finally be dealt with. Because y'all know me, y'all know I've said I've got no filter and I speak my mind. I don't care if you believe me or not. Eventually, everything, all these audio recordings and all that, once all is said and done, is all going to be made public. Every bit of it. Just that way y'all can see that it's exactly what I've been saying this whole time, and nothing's fabricated on my end, nothing's exaggerated, nothing's made up, or any of that shit. And one of the things you'll hear is, take today for example, because again, today I said it. I straight told the case manager whenever she said that it was going to be the panel of judges that were the judges that were actually going to review this, not the commissioners. I said, well, that's good, because we talked about that, and then I went into how, I need this appeal to go through, that way I can get this to the federal courts. I said, because ultimately that's where this is going to the federal courts. It's just it won't be able to be kicked after it goes through the appellate courts. It'll give me more standing at the federal level and make it harder for the state to get it thrown out, which is factual. But I also said I'm setting up the state and the appellate court further by filing the appeal, because at the end of the day, they're not going to address everything that's taken place and that's on the record. So I'm letting them set themselves up, and I'm making it. I've straight up told this appellate court case manager that I'm setting up the appellate court to take a fall with the rest of the state of Washington's judiciary on this by not properly addressing these issues. Because realistically, when the appellate court reviews this record, they should have questions of me, a lot of questions, and they should want documents to prove the things I'm going to say. And when they're provided those documents, it shouldn't take too long after that. So, in the end, we'll see how it plays out. But that's all I got for today. Just wanted to give you all an update. Thank y'all. Love y'all. Peace.